I just need him to live until Monday morning. That's when we signed the papers. Those words, written in an email, would eventually cost Caitlin Wright everything. But when she typed them to her sister on a Friday afternoon, she had no idea anyone would ever see them. She thought she was 3 days away from becoming a multimillionaire. Instead, she was 3 days away from committing one of the most brazen cases of elder exploitation I've ever prosecuted. I'm an estate litigation attorney in San Diego, California. I've been practicing for 23 years, specializing in will contests and cases involving undue influence over vulnerable elderly people. Arthur Stone's case is one I'll never forget. Not because of the amount of money involved, though $15 million is significant, but because of the audacity of what Caitlin Wright attempted, and because of how close she came to succeeding. Let me tell you how a dying man's nurse tried to steal his entire fortune in the final 72 hours of his life. Arthur Stone was 78 years old when this story began. He'd been a successful corporate executive, rising to CEO of a mid-sized tech company in the 1990s. He'd made smart investments, saved aggressively, and built a fortune of approximately $15 million. Arthur had been married for 52 years to his wife, Margaret. They'd raised 2 children together, Lisa, who was 53, and David, who was 50. Both children were successful in their own right. Lisa was a physician, David was an attorney. Neither needed their father's money, but both expected to inherit it eventually. Margaret died of a stroke 2 years before this story began. Arthur was devastated by her death. They'd been inseparable, high school sweethearts who'd built a life together. After Margaret died, Arthur's health began declining rapidly. He was diagnosed with stage 4 pancreatic cancer. The doctors gave him 6 to 12 months to live. Arthur refused aggressive treatment. He'd seen Margaret suffer through chemotherapy for her brain tumor years earlier. He didn't want to spend his final months sick and weak. He wanted to die at home, with dignity, surrounded by his memories of Margaret. Lisa and David supported their father's decision. They arranged for hospice care at Arthur's home in La Jolla, an affluent neighborhood overlooking the ocean. That's where Caitlin Wright entered the picture. Caitlin was 35 years old, a licensed practical nurse who specialized in end-of-life care. She was hired through a reputable hospice agency to provide 24-hour care for Arthur during his final months. On paper, Caitlin's credentials were solid. She'd been a nurse for 12 years. She had excellent references. She was experienced with cancer patients and pain management. What wasn't on her resume was her history of targeting wealthy, dying patients. But I'm getting ahead of myself. For the first few months, everything seemed fine. Caitlin provided competent care. She managed Arthur's pain medications. She helped him with daily activities as his strength declined. She was professional and attentive. Lisa and David visited their father regularly. They appreciated Caitlin's care and professionalism. Arthur seemed comfortable and well-managed. But something changed about 3 months into Caitlin's employment. Arthur's children started noticing subtle differences in their father's behavior and in Caitlin's role. Dad seems more dependent on Caitlin, Lisa mentioned to David after one visit. Like he doesn't want us around as much. He keeps saying Caitlin understands him better. I noticed that too, David said. And did you see how much she's redecorated his bedroom? There are all these new things, flowers, candles. It's starting to look more like her room than his. They also noticed that Caitlin had started joining their private family conversations. When Lisa and David would visit to discuss their father's care or finances, Caitlin would linger in the room, offering opinions, making suggestions. "Your father needs more privacy," Caitlin would say. "All these visitors tire him out." At first, Lisa and David thought Caitlin was just being protective of her patient, but gradually, they realized she was isolating him from his own children. Phone calls became difficult. When Lisa would call, Caitlin would answer and say, "Your father is resting. He can't talk right now." Or, He's having a bad pain day. Maybe call back tomorrow. When David would try to visit unannounced, Caitlin would meet him at the door. Your father needs quiet time right now. He specifically asked not to be disturbed. Lisa and David grew increasingly concerned, but their father was dying. They didn't want to upset him or create conflict during his final months. They told themselves Caitlin was just being overly protective. They had no idea what she was actually planning. Arthur's cancer progressed quickly in month 4 of Caitlin's employment. He became bedridden. His pain increased dramatically. His morphine dosage was increased to keep him comfortable. The stronger pain medications affected Arthur's mental state. He would drift in and out of consciousness. He'd be lucid for brief periods, then confused and disoriented. This is normal for end-stage cancer patients on high-dose opioids. Caitlin documented everything carefully. Each medication dose, each period of lucidity, each moment of confusion. She was keeping records, but not for medical purposes. She was timing something. In the final week of Arthur's life, Caitlin made her move. On a Tuesday morning, Arthur asked Caitlin to help him write a letter. He wanted to express his love for Margaret, who'd been dead for 2 years. The morphine was making him confused. He thought Margaret was still alive, just away on a trip. Caitlin humored him. She helped him write the letter. And while she was helping, she suggested something. Arthur, you know Margaret would want you to be happy. She'd want someone to take care of you, like she did. Arthur, in his morphine haze, agreed. I take care of you now, Arthur. I make sure you're comfortable. I make sure you're not alone. Yes, Arthur murmured. You're very kind. Margaret would approve of us being together, don't you think? Arthur, barely conscious, confused and medicated, nodded vaguely. That evening, Caitlin called a friend of hers, who was a notary public. She asked her to come to Arthur's house the next day. Wednesday. On Wednesday morning, Caitlin had 2 documents ready. She'd prepared them herself, though she later claimed she'd had an attorney draft them. She hadn't. She'd downloaded templates from the internet and filled them in. Document 1. A marriage certificate application. Document 2. A new will, leaving Arthur's entire estate to my beloved wife, Caitlin Stone. The notary arrived at 11 a.m. Caitlin had timed it perfectly. Arthur had received his morning morphine dose an hour earlier. He was awake but heavily sedated. Caitlin positioned Arthur in bed, propped up with pillows. She'd dressed him in a clean shirt. She'd placed flowers in the room to make it look festive. Arthur, honey, remember we talked about getting married? Today's the day. Isn't that wonderful? Arthur looked confused. Married? Yes, to me. So I can take care of you forever, just like Margaret would want. Margaret. She approves, Arthur. She wants you to be happy. The notary witnessed as Caitlin helped Arthur sign the marriage certificate application. Arthur's hand trembled. He could barely hold the pen. Caitlin had to guide his hand to form the signature. The notary looked uncomfortable. Ma'am, I'm not sure he understands what he's signing. Of course he does, Caitlin said firmly. He's having a good day. Aren't you, Arthur? Arthur mumbled something incoherent. The marriage certificate was signed. In California, there's a brief waiting period, but Caitlin had arranged for an expedited processing through a friendly county clerk she knew. The marriage would be official by Friday. On Thursday, Caitlin brought Arthur to sign the new will. She'd scheduled this carefully too. Morning morphine dose, wait 1 hour, then present the documents. This time, she'd brought her sister Melissa as a witness. And she'd brought her personal attorney, a lawyer named Robert Chen, who'd helped her with some legal matters in the past. Caitlin positioned Arthur in bed again. She placed the will in front of him. Arthur, we need to update your will now that we're married. This makes sure I'm taken care of, just like you wanted. Arthur's eyes were unfocused. The morphine dose had been increased the night before. His pain had worsened. Sign here, honey. Caitlin guided his hand to the signature line. Arthur made a weak scrawl. It barely resembled his usual signature. Melissa and Robert Chen signed as witnesses. The will was executed. Caitlin had timed everything perfectly. The marriage on Wednesday, the new will on Thursday. On Friday morning, Arthur Stone died peacefully in his sleep. Or perhaps not peacefully. Perhaps he died confused, wondering why Margaret hadn't come home from her trip. Caitlin waited until Friday afternoon to call Arthur's children. She needed to make sure the marriage certificate had been processed and was officially recorded first. Lisa, David, I have sad news. Your father passed away this morning. Lisa started crying. We'll come right over. Actually, there's something I need to tell you first. Your father and I were married. He wanted me to take care of him. We made it official 3 days ago. There was stunned silence on the phone. You what? David finally said. We got married on Wednesday. It was his wish. He didn't want to die alone. That's impossible. Our father would never. He did. I have the marriage certificate. And he updated his will. He left everything to me, his wife. Lisa and David were speechless. Married? New will? In the final 3 days of their father's life? They immediately knew something was wrong. Terribly wrong. That's when they called me. Lisa and David came to my office that same Friday evening, just hours after learning of their father's death. They were devastated, grieving, and furious. This woman married our dying father and got him to change his will in the final 72 hours of his life, David said. He was an attorney himself, but he specialized in corporate law, not estate litigation. That can't be legal. Tell me everything, I said, pulling out a legal pad. They told me about Caitlin's employment, about how she'd gradually isolated Arthur from his children, about his declining mental state in the final weeks, about the heavy morphine doses. There's no way my father had the mental capacity to marry anyone or change his will, Lisa said. He was dying. He was on massive doses of pain medication. He was confused and disoriented. Did you see him in those final days? Caitlin wouldn't let us visit, David said bitterly. She kept saying he was too tired, too sick, needed rest. We didn't want to stress him, so we stayed away, and she used that time to manipulate him. Do you have your father's medical records? We can get them. Do that immediately. We need to prove his mental state at the time he signed these documents, and we need to move fast. File a petition to contest the will tomorrow. Request a temporary restraining order freezing all of your father's assets until this is resolved. Can we win this? Lisa asked. If what you're telling me is accurate, yes. This is a textbook case of undue influence, possibly even fraud, but we need evidence. Over the weekend, I worked around the clock. I filed the petition contesting the will first thing Monday morning. I alleged lack of testamentary capacity, undue influence, and fraud. I also filed a motion to set aside the marriage as void, arguing Arthur lacked the mental capacity to consent. The legal battle had begun. Caitlin hired an attorney quickly, a lawyer named Susan Porter, who specialized in defending contested estates. Porter filed responses denying all allegations. My client entered into a legitimate marriage with Arthur Stone, Porter wrote in her response. Mr. Stone was of sound mind and freely chose to marry her and update his estate plan to reflect his marriage. Ms. Wright is entitled to her spousal share of the estate. We moved into discovery. This is where I would gather evidence to prove Caitlin had manipulated a dying man. First, I subpoenaed Arthur's complete medical records. What I found was damning. In the week before the marriage and will signing, Arthur's medical records showed morphine dosage increased 3 times, multiple notations of patient confused and disoriented, notes that Arthur was difficult to rouse and minimally responsive, documentation that he'd asked for Margaret multiple times, not understanding she'd died 2 years earlier. The medical records painted a clear picture. Arthur Stone was heavily medicated and mentally compromised in his final days. But the most damaging evidence came from somewhere unexpected. I subpoenaed Caitlin's email and text message records. And in those communications, I found the smoking gun. An email from Caitlin to her sister Melissa, sent on Friday morning, 2 days before the marriage. I just need him to live until Monday morning. That's when we sign the papers. If he makes it through the weekend, I'll have everything. A text message from Caitlin to her friend. This is it. My big break. Rich old man, no other family close by, totally dependent on me. If I play this right, I'll never have to work again. Another email to her attorney, Robert Chen. Bob, I need the will drafted ASAP. He's going downhill fast. We probably have less than a week. Can you have it ready by Thursday? These communications showed clear consciousness of wrongdoing. Caitlin knew what she was doing. She was deliberately manipulating a dying, confused man to steal his fortune. I also discovered something else in my investigation. Caitlin had done this before. 3 years earlier, she'd been a nurse for an elderly man in Arizona. That man had also suddenly changed his will in his final week, leaving everything to Caitlin. The family had challenged, but eventually settled out of court, paying Caitlin $50,000 to go away rather than endure a lengthy trial. Caitlin had a pattern: target wealthy, dying patients, isolate them from family, manipulate them at their most vulnerable, strike in the final days when they're too confused to resist. Arthur Stone was just her latest victim, but this time, she'd picked the wrong family. The deposition of Caitlin Wright was scheduled for 3 months after we filed the will contest. It took place in a conference room at my law firm on a Tuesday morning. Present were myself, Lisa and David Stone, Caitlin, her attorney Susan Porter, and a court reporter recording every word. I'd prepared extensively for this deposition. I had Arthur's medical records. I had Caitlin's damning emails and texts. I had testimony from Arthur's doctors. I was ready to expose exactly what she'd done. Caitlin walked into the conference room looking confident. She wore a conservative dress, minimal jewelry, her hair pulled back neatly. She looked like a caring professional nurse, not a con artist who'd manipulated a dying man. Ms. Wright, please state your name for the record. Caitlin Marie Wright. And you were employed as a private nurse for Arthur Stone, correct? Yes. For how long? Approximately 6 months, from April until his death in October. During that time, what were your duties? I provided 24-hour care, pain management, assistance with daily living activities, companionship, emotional support. Did your role ever extend beyond nursing care? What do you mean? Did you develop a personal relationship with Mr. Stone? We developed a close bond, yes. That's natural when you're caring for someone during their final months. How close? We fell in love. Lisa made a disgusted sound from where she was sitting. David put a hand on her arm. You fell in love with your patient, I asked. Yes. Arthur was lonely after losing his wife. I was there for him. We connected on a deep emotional level. When did this romantic relationship begin? Gradually, over the months I cared for him. Did you disclose this relationship to Arthur's children? No. Why not? It wasn't their business. Arthur was an adult. He had the right to privacy in his personal relationships. Ms. Wright, you married Arthur Stone 3 days before he died. Is that correct? Yes. Whose idea was the marriage? It was mutual. We both wanted to formalize our commitment. Mr. Stone was dying of cancer. He was on heavy pain medications. Why the rush to marry? Because we loved each other and wanted to be together for whatever time he had left. Or because you wanted to secure your claim to his estate before he died. Objection, Porter interjected. Argumentative. I'll rephrase. Ms. Wright, were you aware that Mr. Stone had substantial assets? I knew he was financially comfortable, yes. $15 million. That's more than comfortable, isn't it? I suppose. Did you discuss his assets with him? Not in detail. Did you discuss what would happen to those assets after his death? Arthur wanted to make sure I was taken care of. So you did discuss it. Caitlin hesitated. He expressed concern about my future. He knew I'd dedicated months to caring for him. And so he married you and changed his will to leave you everything. Yes. All in the final 72 hours of his life. He wanted to make sure everything was in order before he passed. I pulled out the medical records. Ms. Wright, I'm showing you what's been marked as Exhibit A. These are Arthur Stone's medical records from the week before his death. Do you recognize these? I kept these records as his nurse, yes. Let's review them together. On the day Arthur signed the marriage certificate, what was his morphine dosage? Caitlin looked at the records. 80 milligrams per day. That's a very high dose, isn't it? It's appropriate for end-stage cancer pain. According to these notes, Arthur was confused and disoriented that morning. Do you see that notation? Yes. You made that notation? Yes. So Arthur was confused and disoriented when he signed the marriage certificate. He had moments of confusion, but he was lucid when we signed the papers. How convenient. He was confused all morning, but precisely during the 10 minutes it took to sign the marriage certificate, he was suddenly lucid? Yes. Ms. Wright, these notes also indicate Arthur asked for his deceased wife Margaret multiple times that week. He thought she was still alive. Do you remember that? He was grieving. Sometimes he got confused about time. He didn't know his wife was dead. But you're claiming he had the mental capacity to marry you? He had good moments and bad moments. And you timed the marriage certificate signing for a good moment? I timed it for when he was most alert, yes. That's very calculated, isn't it? It's being practical. I wanted him to understand what we were doing. I pulled out another document. Ms. Wright, I'm now showing you Exhibit B. This is an email you sent to your sister Melissa on Friday, 2 days before the Wednesday marriage. Do you recognize this email? Caitlin's expression changed. Her confidence wavered. Yes, I recognize it. Can you read the highlighted portion out loud for the record? I'd prefer not to. I'll read it then. You wrote, I just need him to live until Monday morning. That's when we signed the papers. What did you mean by that? I don't remember the context. You don't remember writing an email 2 days before you married your patient, saying you needed him to live until Monday? I may have been talking about something else. What else could you have been talking about? I don't recall. Ms. Wright, you wrote this email on Friday. You married Arthur on Wednesday. The timeline doesn't match your explanation. I must have made a mistake about the dates. Or you were planning this marriage and will change days in advance, waiting for the right moment to execute your plan? That's not true. I pulled out more emails. Exhibit C, an email to your friend Jennifer. You wrote, this is it, my big break. Rich old man, no other family close by, totally dependent on me. If I play this right, I'll never have to work again. What did you mean by that? Caitlin went pale. I was joking. Joking about manipulating your dying patient for his money? It wasn't like that. Then what was it like? I genuinely cared about Arthur. Did you genuinely care about his $15 million estate? Money wasn't my motivation. Really? Then why did you email your attorney Robert Chen asking him to draft a will ASAP because Arthur was going downhill fast and you probably had less than a week? Caitlin couldn't answer. Her attorney, Susan Porter, looked furious. She clearly hadn't seen these emails before. Ms. Wright, did you tell Mr. Stone's children that you were planning to marry their father? No. Why not? It happened quickly. You had time to arrange for a notary, have a will drafted, and coordinate with witnesses. But you didn't have time to make a phone call to his children? I didn't want them to interfere. Interfere with what? With their dying father making a rational decision? Or with your plan to manipulate him? Objection! Porter was on her feet. Counsel is badgering the witness. I'll move on. Ms. Wright, on the day Arthur signed the new will, who was present? Your sister Melissa and your attorney Robert Chen. Is that correct? Yes. Did you select these witnesses? Yes. Why these two people specifically? They were available. Or because they were people who would do what you asked without questioning the situation. That's not fair. Arthur's children weren't present. Arthur's longtime attorney wasn't present. Arthur's doctor wasn't present. The only people present were people you chose. Why? It was easier to coordinate. Easier to control, you mean? No. Ms. Wright, did Arthur review the will before signing it? I read it to him. Did he understand it? Yes. How do you know? He nodded. He nodded. That's your evidence that he understood he was disinheriting his two children and leaving $15 million to a woman he'd known for 6 months? He wanted me to have it. Because he loved you so much in 6 months that he forgot about his children he'd raised for 50 years? Caitlin was silent. Or because he was dying, confused, heavily medicated, and you took advantage of him at his most vulnerable moment? That's not what happened. Then what happened, Ms. Wright? Explain to me how a man who was so confused he thought his dead wife was still alive suddenly had the mental clarity to marry a woman he barely knew and change his entire estate plan. He had moments of lucidity, very convenient moments, lucid enough to sign the papers you put in front of him, but not lucid enough to call his own children to tell them what he was doing. I didn't prevent him from calling anyone. Didn't you? According to phone records, Arthur's phone was used only twice in his final week, both calls made by you. He didn't call his children at all. Why? He was too weak. Too weak to make a phone call, but strong enough to get married and execute a complex will? Caitlin had no answer. Let me ask you something else. Have you ever been involved in a similar situation before? Porter objected immediately. That's irrelevant and beyond the scope of this deposition. It's directly relevant to establishing a pattern of behavior. I'll allow the question, I said, looking at the court reporter. Note the objection for the record, but the witness will answer. Ms. Wright, 3 years ago you were a nurse for a man named Harold Benson in Arizona, correct? Yes. And Mr. Benson changed his will in the final days of his life, leaving you a substantial sum, correct? He left me something, yes. $50,000, and his family challenged the will. And you settled with them rather than go to trial, correct? We reached an agreement. Yes. So this isn't the first time you've been accused of manipulating a dying patient for financial gain. The situations were completely different, were they? Elderly man dying, isolated from family, last-minute will change in your favor? Sounds pretty similar to me. The deposition continued for another 2 hours. By the end, Caitlin's confident demeanor was gone. She looked rattled, caught in lies, exposed. Her attorney, Susan Porter, requested a break to confer with her client. When they returned, Porter made an announcement. We'd like to discuss settlement possibilities. I'm listening, I said. What would your clients accept? Recognition that the marriage and will are void. Return of the entire estate to Arthur Stone's children per the original will, and Caitlin receives nothing beyond her unpaid nursing fees. That's not acceptable. Then we'll see you in court, and I'll present all of this evidence to a jury. Every email, every text, every medical record showing Arthur was incompetent, every bit of Caitlin's pattern of targeting vulnerable patients. How do you think that will play? Porter was silent. Your client committed elder abuse, I continued. She manipulated a dying man in his final days. She isolated him from his children. She timed his medication doses to maximize his confusion. She had documents ready and witnesses lined up. This was premeditated exploitation. We'll take your settlement proposal under advisement, Porter said quietly. 2 weeks later, they called to accept our terms, but they wanted one addition. The settlement would be confidential. Caitlin didn't want this case to become public and damage her nursing career further. I discussed it with Lisa and David. I don't want confidentiality, Lisa said. I want everyone to know what she did. I understand, but confidentiality might make her more willing to walk away completely. No appeals, no further litigation. What do you think we should do? David asked. I think we should accept. You'll get your father's estate. Caitlin gets nothing. And we avoid a potentially lengthy trial. The downside is she faces no public consequences. After much discussion, Lisa and David agreed to confidential settlement. They wanted their father's estate resolved. They wanted to move on. But I insisted on one thing. We'd report Caitlin to the state nursing board for ethics violations. She might escape public scrutiny, but she wouldn't keep her nursing license. The settlement agreement was executed. The marriage was declared void. The new will was set aside. Arthur Stone's original will was admitted to probate. His children inherited his estate as he'd intended. Caitlin received payment for her unpaid nursing fees, about $8,000, and nothing more. Justice, of a sort, had been served. While the civil case was being settled, I had already filed a complaint with the California Board of Registered Nursing against Caitlin Wright. The complaint detailed everything: the manipulation of a vulnerable patient, the isolation from family, the marriage and will changes during the patient's final incompetent days. The nursing board takes such complaints seriously. Elder abuse by healthcare professionals is a major concern, and they have the power to suspend or revoke nursing licenses. The investigation took 6 months. During that time, I provided all our evidence to the board: the medical records, the emails, the deposition testimony, everything. The board also investigated the Arizona case I'd uncovered. They contacted Harold Benson's family and learned that Caitlin had used similar tactics with him. She'd isolated him from his children in his final weeks. She'd been present when he changed his will. She'd received $50,000 before the family negotiated a settlement to avoid trial. A pattern was emerging, and the nursing board didn't like what they saw. The board scheduled a hearing. Caitlin would have to appear and defend her nursing license. I was invited to testify as a witness. So were Arthur's children, his doctors, and several other people familiar with the case. The hearing took place in a government building in Sacramento. The board consisted of 7 members, 5 registered nurses, 1 licensed vocational nurse, and 1 public member. Caitlin attended with her attorney. She looked nervous. She knew her career was on the line. The board's attorney presented the case against Caitlin. He outlined the facts of Arthur Stone's case, the Arizona case, and the pattern of behavior. Ms. Wright has demonstrated a pattern of exploiting vulnerable, dying patients for financial gain, the board's attorney argued. She violates the trust patients place in healthcare providers. She engages in emotional and financial exploitation. She has no place in the nursing profession. Caitlin's attorney argued that the civil case had been settled without admission of wrongdoing, that Caitlin had provided competent medical care, that her personal relationship with Arthur Stone, while perhaps inappropriate, wasn't a violation of nursing ethics. Then it was time for testimony. I was called first. I explained the case in detail: the timeline, the medical evidence of Arthur's incompetence, the emails showing premeditation, the calculated manipulation. This wasn't a nurse who fell in love with her patient, I testified. This was a predator who targeted a vulnerable man and manipulated him in his final days to steal his estate. Arthur's physician, Dr. Sarah Chen, testified next. She explained Arthur's medical condition in his final weeks. Mr. Stone was heavily medicated for pain control, Dr. Chen testified. The morphine doses he was on would have significantly impaired his judgment and decision-making ability. Based on his medical records, I do not believe he had the capacity to consent to marriage or execute a will in his final week. Would a competent nurse have known this? The board's attorney asked. Absolutely. Any nurse working with end-stage cancer patients understands the cognitive effects of high-dose opioids. Ms. Wright knew her patient was impaired. She took advantage of that impairment. Lisa testified about how Caitlin had gradually isolated Arthur from his family. She wouldn't let us visit in the final weeks, Lisa said, her voice breaking. She always had an excuse. He's sleeping. He's having a bad day. He needs quiet. We respected that because we didn't want to stress him. But she was using that time to manipulate him without us there to intervene. David testified about discovering the marriage and will change only after their father died. We had no idea what was happening. If we'd known, we would have gotten guardianship. We would have protected him. But Caitlin made sure we didn't know until it was too late. Then Caitlin was called to testify in her own defense. She maintained that she and Arthur had genuinely fallen in love, that he'd wanted to marry her, that he'd wanted to provide for her after his death. Arthur was lonely after losing his wife, Caitlin testified. I provided companionship as well as medical care. Our relationship evolved naturally. But you didn't disclose this relationship to his family or to your supervising physician, the board member questioning her pointed out. I didn't think it was necessary. You didn't think it was necessary to tell a patient's family that you'd entered into a romantic relationship with him? It was private. Or you knew they would object and potentially remove you from his care. Caitlin didn't answer. Another board member asked about the timing. Ms. Wright, you married your patient 3 days before he died. You had him sign a new will 2 days before he died. Don't you find that timing suspicious? We wanted to make sure everything was in order before he passed. Or you wanted to make sure you secured your claim to his estate before he died. That's not what happened. Then explain the email where you wrote that you needed him to live until Monday to sign the papers. Caitlin couldn't explain it. She claimed she didn't remember the context, that she might have been referring to something else. But her explanations were weak and unconvincing. The board member pressed harder. Ms. Wright, you wrote to a friend that this was your big break, that you'd never have to work again if you played it right. What did you mean? I don't remember writing that. We have the email. Your words. What did you mean by them? I may have been joking. This doesn't sound like a joke, Ms. Wright. It sounds like a calculated plan to exploit your patient. After 2 days of testimony, the board deliberated. 2 weeks later, they issued their decision. The board found that Caitlin Wright had engaged in unprofessional conduct by entering into a personal relationship with a vulnerable patient, violated the duty of care by failing to protect her patient from exploitation, isolated her patient from his family to facilitate her own financial gain, demonstrated a pattern of predatory behavior toward elderly, dying patients, brought dishonor to the nursing profession. The board's ruling. Caitlin Wright's nursing license was permanently revoked. She was banned from ever working as a nurse in California again. The board also reported her to the National Nursing Database, making it difficult for her to obtain a nursing license in any other state. Caitlin's nursing career was over. Outside the hearing, I spoke with Lisa and David. It's not enough, Lisa said. She should face criminal charges. I agree, I said, and I've referred the case to the district attorney's office. But criminal prosecution in these cases is difficult. Why? David asked. Because Arthur is dead. He can't testify about whether he was manipulated. It becomes a matter of interpretation. Civil juries can find undue influence more easily than criminal juries can find fraud beyond a reasonable doubt. So she just walks away? She lost her nursing license. She lost the inheritance she tried to steal. She's been publicly exposed. Those are consequences. Not criminal consequences, but real consequences nonetheless. I want her in prison, Lisa said. I understand. Let's see what the DA says. I had indeed referred the case to the district attorney's office. An assistant district attorney named Michael Torres reviewed the evidence. He called me a month after the nursing board hearing. This is a strong case for elder abuse, Torres said. The evidence of manipulation is clear. But there's a problem. What's that? Arthur's gone. We can't prove criminal intent without his testimony. Caitlin will claim she believed Arthur wanted to marry her and change his will. Without Arthur to contradict her, it's hard to prove she knew she was manipulating an incompetent person. What about the emails? They show clear consciousness of wrongdoing. They show opportunism, maybe even callousness. But do they prove criminal fraud? A defense attorney will argue she was just being pragmatic about timing, that she genuinely believed Arthur wanted to marry her. What about the Arizona case, the pattern? Prior bad acts are generally inadmissible in criminal cases. We can't use that to prove she committed a crime in this case. So you won't prosecute? Torres sighed. I want to. This woman is predatory and dangerous. But I have to be realistic about what I can prove beyond a reasonable doubt. A jury might not convict. So she faces no criminal consequences? Not unless we find stronger evidence of intent. If you discover anything else, more emails, witnesses to statements she made, anything that shows she knew Arthur was incompetent, call me immediately. I was disappointed, but not surprised. Criminal prosecution in elder abuse cases is notoriously difficult. But I wasn't done with Caitlin Wright yet. I started investigating her background more thoroughly. I wanted to know if there were other cases, other victims, other families she'd exploited. What I found was disturbing. Over the past 15 years of her nursing career, Caitlin had been employed by 7 different hospice agencies in 4 different states. She'd been fired from 3 of them, though the reasons were vague in her employment records. I contacted those agencies and asked questions. Slowly, a picture emerged. In Nevada, a family had complained that Caitlin had become inappropriately close to their dying father and had tried to convince him to change his will. The agency investigated and terminated her employment, but the family didn't pursue legal action. In Oregon, Caitlin had been fired for accepting a gift of jewelry from a dying patient without disclosing it to the family or the agency. Again, no legal action was taken. In Texas, there was a complaint that Caitlin had isolated a patient from family members and made unauthorized medical decisions. The agency settled with the family quietly and fired Caitlin. There was a pattern spanning years and multiple states. Caitlin specifically sought out positions with wealthy, dying patients who had limited family involvement. She'd isolate them, manipulate them, and try to secure financial benefits. Arthur Stone wasn't her first victim. He was just the first one where the family fought back successfully. I compiled all of this information and sent it to every hospice agency in California. I wanted to make sure Caitlin could never work in elder care again, even if she somehow got her nursing license back in another state. I also contacted the families of her previous victims. Some were aware they'd been manipulated, but had chosen not to fight. Others had never realized what happened. One family in Oregon, the Martins, reached out to me after receiving my letter. "We always felt something was wrong," Mrs. Martin told me on the phone. Our father changed his will right before he died and left money to his nurse. We were upset, but we didn't want to fight. We thought maybe he genuinely cared about her. How much did he leave her? $25,000. Not enough to fight over, we thought. Would you be willing to tell your story publicly, to warn other families? Yes, if it prevents this from happening to someone else. Over the next few months, I connected with 4 families who'd been victimized by Caitlin in various states. Together, we decided to do something unprecedented. We contacted a journalist at the Los Angeles Times who specialized in healthcare fraud. We told him Caitlin's story and provided all the documentation. The journalist, David Chen, investigated for 3 months. He interviewed all the families. He reviewed court documents, nursing board records, employment files. His article, titled "The Nurse Who Married Her Dying Patients: A Pattern of Predatory Behavior," was published 6 months after the Arthur Stone case settled. The article detailed Caitlin's 15-year pattern of targeting vulnerable, dying patients. It included interviews with multiple families. It explained how the system had failed to stop her despite repeated warning signs. The article went viral. It was picked up by national news outlets. Suddenly, Caitlin Wright was infamous. More victims came forward. Families who'd been manipulated by Caitlin but had never reported it. One family in Arizona said Caitlin had convinced their dying mother to loan her $30,000 that was never repaid. The attention prompted investigations in multiple states. Nursing boards in Oregon, Nevada, and Texas all opened investigations into Caitlin's conduct while she'd practiced in their states. Caitlin disappeared from public view. She deleted her social media accounts. She moved from her apartment. She essentially went into hiding. I heard through mutual contacts that she'd moved to a small town in rural Montana, trying to escape the publicity and start over. But her reputation followed her. A Google search of her name brought up the LA Times article and dozens of follow-up stories. She'd never work as a nurse again. She'd never be able to exploit vulnerable patients again. In a way, that was a greater punishment than prison might have been. Her entire identity had been built around being a nurse. That was gone now. Permanently. 2 years after the Arthur Stone case concluded, I received a call from a state legislator named Jennifer Liu. She'd read about the case and wanted to discuss potential legislative reforms. Cases like Arthur Stone's shouldn't be possible, Liu said during our first meeting. There should be protections in place to prevent nurses and caregivers from exploiting dying patients. I agree. What are you thinking? I want to introduce legislation requiring enhanced scrutiny of last-minute estate changes when a caregiver benefits. What would that look like from a legal perspective? We spent months working on draft legislation. The bill we created, informally called Arthur's Law, included several key provisions. Automatic review. Any change to a will or estate plan made within 90 days of death that benefits a healthcare provider would automatically trigger a court review for undue influence. Caregiver restrictions. Healthcare providers would be prohibited from witnessing wills or estate documents for their own patients. Mandatory reporting. Healthcare agencies would be required to report any instance of a caregiver entering into a personal or financial relationship with a patient. Capacity assessment. Any person over 65 making substantial changes to estate documents would be required to undergo an independent capacity assessment by a qualified medical professional. Family notification. Healthcare providers would be required to notify designated family members of any significant changes in a patient's estate planning during end-of-life care. The bill faced opposition from nursing associations, who felt it unfairly stigmatized caregivers. Some attorneys argued it created too much bureaucracy. But families who'd been victimized by predatory caregivers rallied behind it. The Stones testified before the legislature. So did the Martin family from Oregon and several others. Lisa Stone's testimony was particularly powerful. My father was a brilliant man who built a successful career and a loving family. In his final days, when he was at his most vulnerable, a woman he trusted exploited him. She isolated him from his children. She manipulated him while he was confused and medicated. She tried to steal everything he'd worked for. If Arthur's Law had been in effect, none of that could have happened. The automatic review would have caught the marriage and will change. The capacity assessment would have documented his incompetence. The family notification would have alerted us before it was too late. This law won't bring my father back, but it will protect other families from experiencing what we did. After 18 months of advocacy, Arthur's Law passed the California legislature and was signed by the governor. It became a model for similar legislation in other states. I continued practicing elder law, but I also became an advocate for elder abuse prevention. I gave talks at law schools, medical schools, and nursing schools about recognizing and preventing exploitation. One of the most rewarding aspects of this work was connecting with other attorneys handling similar cases. I heard from a lawyer in Florida who'd just taken on a case remarkably similar to Arthur's. An elderly man with Alzheimer's had married his caregiver 3 weeks before his death and changed his will to leave her everything. I shared our strategies, our evidence-gathering techniques, our expert witnesses. The Florida attorney successfully challenged the will and the marriage, citing our case as precedent. I heard from attorneys in Texas, New York, Pennsylvania, Oregon, all handling variations of the same pattern: caregiver exploitation of vulnerable elderly patients. Some of these cases involved marriage, like Arthur's. Others involved loans that were never repaid. Some involved joint bank accounts opened in the patient's final days. The tactics varied, but the goal was always the same: steal from the vulnerable. Each time, I provided guidance and support. Each time, we fought for justice. I also worked with Lisa and David Stone on something personal: a foundation in Arthur's memory. The Arthur Stone Foundation for Elder Protection provides legal assistance to families fighting caregiver exploitation. If a family suspects their elderly loved one is being manipulated but can't afford legal representation, the foundation helps fund their case. My father would have wanted his legacy to protect others, David said at the foundation's launch event. He was a generous man who cared about justice. This foundation honors that. The foundation has helped dozens of families over the past 3 years. Some cases involve nurses, like Caitlin. Others involve professional friends who befriend wealthy elderly people and manipulate them. Some involve family members exploiting their own relatives. The common thread is always vulnerability and exploitation. About 3 years after the Arthur Stone case concluded, I received an unexpected email. It was from Caitlin Wright. Subject line: Apology. I almost deleted it without reading, but curiosity got the better of me. Mr. Vance, I know you have no reason to read this email or believe anything I write, but I need to say it anyway. I'm sorry for what I did to Arthur Stone and his family. I'm sorry for the pain I caused. I'm sorry for the betrayal of trust. I've spent the last 3 years in therapy, trying to understand how I became someone capable of such manipulation. The truth is, I saw elderly patients as opportunities rather than people. I justified my actions by telling myself I deserved to be compensated for my care, that these wealthy people wouldn't miss the money. But that was a lie I told myself. What I did was exploitation, pure and simple. I targeted vulnerable people at their weakest moments. I violated every ethical principle of nursing. I can't undo what I did. Arthur is gone. His children suffered. My actions have consequences I'll live with forever. I'm not writing this to ask for forgiveness. I don't deserve that. I'm writing because you should know that your work and the publicity around the case stopped me from hurting anyone else. I will never work as a nurse again. I will never have access to vulnerable patients again. In a strange way, losing my career saved me from myself. I work in retail now. I make minimum wage. I live in a small apartment in Montana. My life is nothing like what I imagined when I was manipulating Arthur. But I'm not the predator I was. Therapy and consequences have changed me, or at least, I hope they have. I'm sorry. To you, to the Stone family, and to every family I hurt. Caitlin Wright. I forwarded the email to Lisa and David, asking if they wanted to respond. They both said no. She doesn't get to ease her conscience by apologizing, Lisa said. She made her choices. Now she lives with them. I respected their decision. I wrote back to Caitlin with a brief response. Your apology is noted. The Stone family has chosen not to respond. I hope you've truly changed. The best thing you can do now is ensure you never exploit anyone again. She never replied. I never heard from her again. But her email stuck with me. Not because I felt sorry for her, I didn't, but because it confirmed something I'd always believed. Consequences matter. Caitlin was stopped not just by losing the Stone case, but by the publicity, the criminal investigation, the nursing board revocation, the national attention. All of those consequences together changed the trajectory of her life. If we'd settled quietly with confidentiality, as she'd wanted, she might have tried again. She might have found another elderly victim in another state. Instead, she was exposed. Her pattern was revealed. She became infamous as a cautionary tale, and she'll never exploit anyone again. Recently, I gave a presentation at a legal conference about the Arthur Stone case and the lessons learned from it. About 200 attorneys attended, many handling their own elder exploitation cases. After my presentation, a young attorney approached me. She'd just taken on her first will contest case involving caregiver manipulation. Your case gives me hope, she said. I'm trying to help an elderly woman's children challenge a will change made while their mother had advanced dementia. The caregiver claims it was the mother's wish, but I know it was manipulation. Do you have medical evidence? Yes. The mother's doctors have documented her cognitive decline. She wasn't capable of making these decisions. Then you have a case. Document everything. Get the medical records. Look for emails or texts showing the caregiver's intent. Build your timeline showing when the manipulation occurred. Did you ever doubt you'd win the Stone case? At times, yes. These cases are difficult. The victims can't testify. We're reconstructing what happened based on circumstantial evidence. But if you have good facts and compelling evidence, juries understand exploitation when they see it. Thank you. Your case showed me this is possible. That conversation reminded me why I do this work. Not for the money. Will contests are time-consuming and emotionally draining. But for the justice. For the families. For the vulnerable elderly people who can't defend themselves. Arthur Stone couldn't defend himself in his final days. Caitlin Wright made sure of that. She isolated him, medicated him, confused him, and exploited him. But his children defended his memory. They fought for his true wishes. They exposed the person who'd manipulated him. And in doing so, they've helped protect countless other families from similar exploitation. Lisa and David Stone both moved forward with their lives after the case concluded. Lisa continued her medical practice. David continued his legal career. They used their inheritance to secure their family's futures and to fund the foundation in their father's memory. I think about Dad every day, Lisa told me recently. Not about how he died or what Caitlin did, but about who he was, his humor, his intelligence, his love for our mother, his pride in his family. That's the right way to remember him. The case forced us to focus on the worst moment of his life, but that wasn't who he was. He was so much more than the victim of exploitation. He was, and the foundation ensures his legacy is about protection and justice, not about being victimized. Exactly. Caitlin tried to steal his money. She tried to steal his legacy, but she failed. Dad's legacy is helping other families fight back against exploitation. That's better than any inheritance. As I reflect on the case now, several years later, the lessons remain clear. First, vulnerability is exploited. Elderly people with substantial assets, no close family supervision, and declining capacity are targets for predators. Families must remain vigilant, even when, especially when, care is being provided by seemingly trustworthy professionals. Second, timing matters. Most exploitation occurs in the final days or weeks of life, when the victim is most vulnerable and least able to resist. Any dramatic changes to estate plans during this period should be scrutinized carefully. Third, isolation is a red flag. When caregivers prevent family access or make it difficult for families to spend time with their elderly relatives, that's a warning sign of potential exploitation. Fourth, documentation is crucial. Medical records, emails, texts, witness statements, all of this evidence is essential to proving undue influence after the victim has died. Fifth, consequences matter. Civil judgments, nursing board sanctions, criminal investigations, and public exposure all serve important purposes in stopping predatory behavior. And finally, legislation can create real change. Arthur's Law and similar statutes in other states have made it harder for caregivers to exploit vulnerable patients. The legal system can evolve to protect those who need protection most. I still practice elder law. I still take will contest cases. And I always think of Arthur Stone when I do. A man who deserved to die peacefully, surrounded by family, in the home he'd shared with his beloved wife. Instead, he died confused and manipulated, exploited by someone he'd trusted to care for him. But his children fought back. They exposed the truth. They got justice. And they turned their father's victimization into a legacy of protection for others. That's the real ending to Arthur Stone's story. Not the exploitation, not the betrayal, but the justice that followed. 5 years after my father's death, people ask me what families should do to protect their elderly loved ones from exploitation. Here are the most important lessons I learned. 1. Stay involved. Don't let caregivers, no matter how professional they seem, isolate your elderly relatives. Visit regularly. Call frequently. Be present. 2. Trust your instincts. If something feels wrong, investigate immediately. Don't worry about offending the caregiver or seeming suspicious. Your loved one's protection is more important than being polite. 3. Review financial records regularly. Look for unusual withdrawals, new accounts, or changes in financial patterns. Exploitation leaves a paper trail. 4. Be suspicious of last-minute changes. If your elderly relative suddenly wants to change their will, get married, or make major financial decisions, especially when they're ill or medicated, question it. Insist on independent capacity assessments. 5. Know your legal rights. If you suspect exploitation, contact an attorney immediately. The earlier you act, the more you can protect. 6. Document everything. Keep records of concerning behavior, conversations, and incidents. This evidence will be crucial if you need to take legal action. 7. Report suspected abuse. Contact Adult Protective Services nursing licensing boards, and law enforcement when you see exploitation. Even if you don't pursue legal action, your report might protect the next family. My father deserved better than what Caitlin Wright did to him. But by fighting back, we've helped ensure other families' fathers, mothers, and grandparents are better protected. That's my father's legacy, and I'm proud to carry it forward. Lisa Stone, MD. If this story resonated with you, please subscribe for more real legal cases about protecting vulnerable loved ones and seeking justice. Share this with anyone caring for elderly relatives. Remember, isolation is a red flag. Dramatic last-minute changes should be questioned, and families have the right to protect their loved ones from exploitation. Stay vigilant, trust your instincts, and never hesitate to seek legal help if something feels wrong.